morning. Welcome. Grab your last cups of coffee. Grab your snacks. We're ready, or songs, I should say. We're ready to go. And I want to welcome all of you to what is going to be, in fact, the most comprehensive Law Review Symposium ever to look at legal affairs journalism. That's kind of amazing when you consider just how important the coverage of the court and law is. And in terms of the proper exercise of, and functioning of our democracy, one of the big things, of course, that the media does, not the only thing, but one of the things that it does is tell us how our government's operating, including the courts and the law. So we're doing this to celebrate the life of one of the real pioneers of doing this. Anthony Lewis, a longtime New York Times reporter and columnist, and a genuinely wonderful human being. And we've got a terrific lineup of people here who are going to be addressing the issue, not so much about great Anthony Lewis, because while that is true, we thought that the best way to honor him was to really take a look at the past, present, and future of this field that he helped to found. Those of us, and I had the privilege of working in this field for many years, those of us who have worked in this field really have the privilege of being able to stand on his shoulders. Not just his, but he was certainly one of the leaders, and so it's a good occasion to do this. I should say also that this program is actually a partnership, or sponsored by the Center for the Study of Conflict Law and Media. It is a partnership of our law school and the School of Journalism here. We've been working together for many years now, and doing some things like this, and it's been wonderful. So just to give you a few welcomes, I want to ask our Dean, Gary Myers.
I'm back here.
Here it is. Dean Gary Myers to say a few welcoming remarks.
Thank you, Richard. And first of all, welcome and good morning. I want to thank the Reynolds Journalism Institute and the University of Missouri School of Journalism for co-sponsoring this event. And I also want to thank Richard for all of his great work, and ask you all to join me in a round of applause. I know it's going to be a great program. It's very timely. Obviously, Anthony Lewis played an amazing and important role in law and journalism. This being 2014, it's the 50th anniversary of the publication of his book, Gideon's Trumpet. It's also the 50th anniversary of the Supreme Court decision in New York Times versus Sullivan, which addressed the First Amendment and defamation law. So I think it's a particularly apt occasion. And I think this is a particularly appropriate place for this conference. There are amazing connections between law and journalism as professions. We both focus on communicating ideas, positions, facts, and events. And so having the journalism school and the law school sponsor this, I think, is also very appropriate. So thank you all for coming, and welcome.
Dean's schedule is extraordinarily busy. I think we've got Dean Myers for another 30 seconds before he dashes out. Dean Mills, Dean Mills of the Journalism School, unfortunately had scheduling conflict that he really couldn't get out of. So to welcome you from the Journalism School, we have Esther Thurston. Esther's been a wonderful partner. She's coming down. I'll say she's been a wonderful partner. And it's kind of fitting anyway, because anybody who knows the J School knows we all work for Esther anyway. So.
Well, you're going to get some topics too, so just hang on. Well, on behalf of Dean Mills, who is very sorry that he couldn't be with us this morning, and the School of Journalism, which of course is the oldest school of journalism, 105 years young this year, we'd like to welcome you to this symposium. I think Anthony Lewis really combined vibrant, alive writing with an encyclopedic knowledge of the Supreme Court. And certainly at the First Amendment, we might not all agree with his interpretations of that First Amendment, but very, very important. And, you know, the role that he played in making the workings of the Supreme Court understandable to ordinary Americans is such an important journalistic achievement. And I think that Mr. Lewis really does a good job of sort of representing the relationship that we have created between the law school and the journalism school here. This is just a blatant self-promotion thing. If you come to the journalism school or the law school here, you can simultaneously work on a degree in the other department. And in fact, so you can combine our PhD or our master's degree with all kinds of, actually both of the law degrees offered here, saving yourself 1 year total. So instead of it taking you 7 years, you can get out in just 6 years. I really, and I do want to say a great thank you, shout out to Richard, who worked endlessly with us to create all these joint curricula, which was not easy. And I also want to thank former Dean Larry Desmond, who was always supportive for the interdisciplinary work that we did with the two departments. And in fact, I want to brag about some of our graduates. John Peters here is a PhD with us and also teaching in the law school and the journalism school at the University of Dayton, and you're going to hear from him this afternoon. Outstanding young student. Also, at our national organization, Association for Education in Journalism and Mass Communication, the head of the Law and Policy Division is Chip Stewart, who you all know did his law degree over here and his PhD with us in journalism. Very young scholar that just rising to the top very, very quickly, and I think he and John both really represent the kind of quality that you see coming from these programs. So with that said, I'm sorry I won't be able to be at every session today because we also have a major event over at Jason, naturally. But welcome to all of you. I hope you have a wonderful day, and if you have a chance, actually, they are going to come and see
They're going to
us
get a school
today.
School of Journalism School, and then the reception will be.
That's right.
Yeah.
Welcome.
Randy Pick, unfortunately, could not be here. He is the director of the Reynolds Journalism Institute, something that I know that Esther worked very long and hard on helping to create. They're about many things over there, but one of them is to figure out what the next iteration of journalism is. I suspect that's where he is right now. So it's a tall order. Just a few ground rules before we get started. First of all, this is going to be taped and recorded, so I've asked all the speakers to sign the appropriate waivers, and you're in a law school, what can I tell you? And so if you haven't done that, please go ahead and take care of that detail. The second thing is we're going to be a little tight on time in the morning, and this is somewhat deliberate. And so I'm going to ask you to hold your questions until after the presentations rather than as they're going along, so we can go ahead and get through the presentations. Even then, we may have time, depending upon how things go, just for one or two. Then the good news is that we're going to have a lot of time this afternoon for those questions. So this is my way of keeping you here, right? And so we'll have about an hour, and during that period, we're going to it'll be open. So if you have questions about this, about particular presentations, or if you have questions about what's going on at the court or in the courts. So it ought to be a lot of fun. So. With that said, I'm going to go ahead and ask our first panelist. We'll be working in panels of two, come on, I'll make the introductions as the panels are going along. I'm going to say right now that we have such an extraordinary group of presenters, both here and those who will be presenting in the have papers in the final symposium, written symposium. That if I were to go over everyone's merit and qualifications, we would be here all day. They would never get a chance to talk. So I'm really going to be very brief about this. I asked you to take a look at their bios. It's truly amazing what our speakers have done. And instead, I'm just going to give you a sense of who they are now, so to speak, and why they're here. Opening this up, giving us the big picture, if you will, are two wonderful speakers, one from here, one from Washington. Judge, Dean, we have to sort of figure out what they're calling me so accomplished, but Michael Wolff is now Dean of the St. Louis University Law School, and by all reports is doing fabulous over there. Still relatively new position, a couple of years. He has been, as we all know, here in Missouri, State Supreme Court Justice for many years, Chief Justice for some years, has a wonderful history in public service law, public interest law, and actually has a reporting background. And so that's why, and has long-standing interest in this issue. Gene Policinski is in from Washington, D.C. He is currently, among other things, among his many hats, the COO of the Newseum, which is one of the neatest places to go in Washington, D.C. I promise you. And you can set them up later.
Yes. Money on the other podium.
Yeah, thank you. But it's one of the coolest places to go in Washington, D.C., bar none. And that says a lot right there. He's also been one of the leading voices on First Amendment issues, both on radio, TV, online. Currently has a syndicated show on this effect. I think that's right. And he's going to help us see the big picture of this relationship between law and media from the sort of the media side of things. Judge Wolff is going to do it from the sort of the law side of things, and I think you'll find that what they have to say is, both of them have to say is provocative. So no further ado. Preferences?
Good morning.
Stand
I'll use the podium because I'm kind of nearsighted, and farsighted, odd-sighted. I'm really honored to be here to talk about this topic, about how journalism covers courts, and what I want to do is turn it around a little bit about, talk about how courts express themselves. So some of you, when you start working for judges, you can tell them what they're doing wrong. Just saying. Go gently, however. I also, like many of you, was profoundly influenced by reading Gideon's Trumpet, which was an assigned book when I was in college. It was actually fairly newly published then. And it was assigned reading in a course in government. And at the time, I was editor of the student daily newspaper, the Dartmouth, and I had a faint interest in law. Some of my colleagues tell me I may still just have a faint interest. But I knew very few lawyers, and I had only a vague notion of what they do, other than what you see on movies and television. So I thought that the book itself filled that in so nicely. When I went to law school, I worked during law school as a copy editor and then as a reporter for the Minneapolis Star while attending the University of Minnesota. What I think about Gideon's Trumpet, I think that it has taught us a lot about how we educate the public about law and how to communicate law in a way that they will understand and respect it, because law is ultimately about stories, and stories about people. The legal journalism that was really, I think, spawned by Gideon's Trumpet and other kinds of works really deepened the public's understanding and appreciation to the extent that the public reads those kinds of things, but about really how law affects real people. And if they didn't read the book, there was a movie later, I think about 15 or 20 years later, that was, pretty good. But I think it's been an important counterweight to what we now see as the shallow criticism of lawyers, judges, and lawmakers that has populated the ever-proliferating media, much of which, unfortunately, functions without apparently the need for editors. Early in my legal career, I was a law clerk in the federal courts, and I drafted orders and opinions that were the kind of ordinary legal analysis that one can acquire in law school. The intended audience was either the judge for whom I clerked, or, should he decide to put it out as a decision or opinion, the audience might be the lawyers in the case, their clients, the lawyers in the community, or those who are interested in that kind of case. The district judge, for whom I clerked, believed, and I think probably correctly, that very few district court opinions are actually worth reading. And so he seldom chose to publish them in the federal supplement report. And I think that as such, our words were really intended for a relatively small audience. And they were written in the code or jargon of judicial opinion writing, which I believe is part of the secret language that we in our union, the Amalgamated Lawyers and Judges of America, use to keep our shop closed. Okay? Now, the interesting thing about that from that era was that the idea, say 40 years ago when I was a law clerk, actually it was more than that, that a court might actually have a public information officer was probably unimaginable. It was even more absurd to imagine that a reporter would call up a judge and ask the judge what he or she meant by a particular turn of phrase or something that they were discussing. Reporters, mostly from the mainstream, well actually then it was the only stream media, television, newspaper, and radio, were left to their own wits to ascertain what it was that what the judges were talking about. In the 1990s, when law became more of a publicly traded commodity, if you will, courts, including the Supreme Court of Missouri, began to hire public information officers. And it may strike you as kind of odd when you think about it as to why a court that communicates with words should need someone assigned to communicate, to explain to the media representatives and sometimes to the public itself what the judges meant by those collection of words that they put in their opinions. But today we take it for granted that public information officers are essential to the operation of a state Supreme Court. And I was really happy to have worked with Beth Riggert, who's here, and to be on the panel. As time went on, we worked together as we did a monthly column for the newspapers around the state, trying to counteract some of the dumb things that people said in newspapers about law and judges. And in our working relationship, I came to rely upon her and to look over drafts of opinions before I circulated to my colleagues, because she's really a terrific editor. So, what about judicial communications? We lawyers and judges, of course, as I mentioned, we write words. Judges, legislators, executive branch officials write and use words to express something we call law. Law, of course, is nothing if it's not communicated, if it's not understood, both by those who are writing it and those who are receiving it. And I want to take you back to the medieval societies that had law speakers. In Scandinavian countries and in Iceland itself in the 10th century had an official position called a law speaker, and he was a person who memorized law and spoke it. And those who listened to it would receive what the law is. And so if you think about that as a concept, then you think, well, do we have law speakers today? And I suppose you could say, well, how about these attractive former prosecutors who've been populating the cable networks ever since O.J. Simpson got us obsessing about race and crime and sex and whatever else we were obsessed. But enough about Greta Van Susteren, okay? But you also have the justices of the Supreme Court traditionally read their opinions from the bench. I suppose they were law speakers, although they still won't let TV cameras in to capture them and make media stars of them, so whatever. And actually, there's some other law speakers, these people in the Congress, you see them, if you visit the actual Congress, you'll see them making speeches to an empty room, but actually to the one person who matters, and that's the C-SPAN camera. So I'm just giving examples of the way we communicate law or things about law, because few people actually read law in its original source works. I mean, who wades through the pages of court opinions, excessive pages, I might add, or the Byzantine structures of the Affordable Care Act? I kept hearing when they were working on that it was 2,800 pages long. Yeah, I'm sure everybody read it. And I'm just talking about the people who voted on it. Okay? So we rely upon people who read the law to tell us what it is. In that sense, we may be a little better informed than those in the medieval public who were not within earshot of a law speaker, but who heard something about what the law speaker said from someone who heard it from someone else who said he had heard it firsthand. That's sort of how we get the law here, right? So both the medieval citizen and the modern information seeker of information oftentimes is plagued with misinformation. And distortions are bound to occur. When I was early in teaching, I used to teach law to medical students, and I was always impressed about how much law medical students already knew. They knew a lot of stuff. In fact, I came to regard hospitals, teaching hospitals, as places where law is communicated as readily as hospital-borne infections. And let me give you an example. And for those of you who've taken torts recently, forgive me, it's probably in torts court. But a generation ago, Washington, the Supreme Court of the state of Washington, held that an ophthalmologist doing an eye examination was negligent for not doing a glaucoma test to detect glaucoma in its early stages, regardless of the age of the patient. The standard of care at that time was that glaucoma test was not done on patients who were under the age of 40, but the case Helen versus Carey, the Supreme Court of Washington said that the profession's own standard of care was inadequate. You had to give the glaucoma test or be held in jeopardy of being negligent. That was the holding of the Supreme Court of the state of Washington, affecting, of course, the common law of the state of Washington, which is subject to revision by the legislature of the state of Washington. Within a few years of the decision, however, I was in having an eye examination done by an ophthalmologist, and he said he was going to give me a glaucoma test. And I asked him why. And he said, because the law required it. Now, I was in St. Louis, Missouri. I was familiar with the law as propounded by the Missouri Supreme Court and the legislature of Missouri, and I knew there was no such law. But I know that I'm sure that there was a report of the Washington State Supreme Court decision that was carried prominently in journals and magazines that ophthalmologists and optometrists regularly read, and those who read those journals pass the word along to their fellow practitioners that this is indeed what the law requires. So I always referred to this as the holy crap phenomenon. As in, holy crap, now we've got to do this, and the courts tell us we've got to. And then, you get some cases that just by their nature get distorted. One of my favorites was the Kelo case out of the U.S. Supreme Court about eminent domain law, where everybody in the blogosphere went crazy about how the courts were taking property away from poor property owners and giving it to richer property owners, all of which, by the way, was probably correct. It's just that they were blaming the wrong branch of government, because that was actually giving the court deference to a legislative body, I believe it was the city council of New London, Connecticut or somebody. But nevertheless, that was the courts doing it. And by the way, I was in the Supreme Court of Missouri at the time, and there were resolutions introduced to change the Constitution of Missouri. By God, make sure that determinations of public use were a judicial function, which I thought was a great tribute to the least corruptible branch of government. And those resolutions actually went nowhere because somebody pointed out to the sponsor of the resolution that actually that's exactly what the Supreme Court, or that the Constitution of Missouri requires. Is that the finding of a public use is a judicial determination and not to be made by anybody else. So we were held decades ahead of our time. So another recent example, kind of a local example, is you've heard about the so-called Turner problem. That's the name of a case that came from the Supreme Court of Missouri that says that a school district that loses accreditation has to pay for students who choose to attend school in an accredited district. What is impressive is the number of times I've heard about this referred to as the Turner problem, as though it is as though it is a problem that was caused by the Supreme Court of Missouri. Indeed, the court has dealt 2 times with the so-called Turner problem, and in both times, the court has said simply this: the law is precisely as the legislature wrote it. This is wonderful because it gives politicians the opportunity to blame the court for confusion that is caused when their predecessors who passed the law did not explain how it might be implemented, for instance. And so this was all very convenient until some people in the public figured out that you could work that out through legislation. And that may occur someday, but don't hold your breath. So we live in a world where court decisions can be interpreted, misinterpreted. Early on in my 13 years in the Supreme Court of Missouri, I came to believe that the audience I was writing for is in fact the lay public, the litigants, but not the lawyers. I also came to believe, under the influence of journalism, that legal cases can be good stories if the story of the case is well told. And I think that stories make the legal principles understandable, and that certainly is one of the lessons of getting this trumpet. An early leader, and I think pioneer was the right word for that. I've often thought that judges should strive to make their opinions clear and interesting. There are thousands of judicial opinions. Not many of them are very interesting. They do, in fact, seem somewhat redundant. So I think to promote clarity, what we do is we copy the best of what journalism does, which is to write as though, and I said this to a group of editors of Missouri newspapers, as though as we were taught as journalists to write for the 5th grade audience. Somebody interrupted me and said, no, it's a 6th grade audience now. That depressed me a little bit because of the commentary on the state of public education. But whether 5th grade or whatever, a good opinion has a lead. It summarizes something up front, what you're going to do, tell them what you're going to do. You go point by point, we call them points in Missouri, issues if you want to be more general about it. Avoiding jargon, because when you're reading something as an average layperson, the word plaintiff, respondent, appellate, that kind of stuff, it just stops you cold because you have to think, now who the hell is that? And so you always want the reader to feel just as smart as the writer, because when the reader feels stupid, he stops reading. I think there's a rule about that someplace. It's written in human nature. We shouldn't string legal case citations together, blah, 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 blah. They can go in the footnotes because footnotes show the reader that the law clerk has read all the pertinent cases. And at the end, we summarize succinctly what the court has done and what it means. Now, I said clear and interesting. Sometimes, if you can't make it, you at least should make it interesting. You're sort of in the position of, I always thought, like Elizabeth Taylor's 7th husband. You know what you were supposed to do, but you didn't know whether you could make it interesting. Unlike the husband, if you cannot make it interesting, at least make it brief. That way fewer trees will die. If there's something about the case, it might be a routine case, you have to tread lightly. You don't want to make fun of the parties or the witnesses or something. But we had a case one time I was assigned to write the opinion. The fellow had refused to sign his property tax valuation oath because it required him to sign, so help me God. So, I could not help but start out the opinion with the following sentence. Robert E. Oliver, an atheist residing in Christian County. I don't know if anybody got the joke. An atheist living in Christian County. By the way, we didn't strike down the statute. We just said he was free to cross out the words, so help me God, and his oath would be just as good. And I think that's a good lesson for us all. We can still cross out a bunch of words, have fewer words, and our work is probably just as good. So help me God. I close by answering a question. I guess I was talking about how the courts could do a better job. You think, well, was that really his topic? And I thought, well, that is my topic. And I really do think that if judges feel that journalism and journalists are not getting the right, the first thing that we should do is make sure that judges are speaking law as clearly as they can. And I start or end with a quote, misquote, from Shakespeare's Julius Caesar. The fault dear Brutus, lies not in our media stars, but in ourselves. And I think when I start to rewrite Shakespeare, it's time for me to stop. So help me God.
Wonderful talk. And while Gene is taking the stand, I feel a little awkward now as speaker of law. I feel conscious now. Let me just also say, I didn't mention this about Gene Policinski. He has actually thought a lot about this connection in terms of law and journalism as the facilitator of a series of programs that's gone on within the federal judiciary over many years, and he's been one of the primary facilitators, and so you wouldn't have gotten that from the program. It's really worth knowing about it. So, thank you.
And I beg your indulgence as well to the questions at the end of the hour or the day, because David Sellers has been partner in that effort, a program we call Justice and Journalism, so you can rise to object any time, David, I think. We'll go around the ground rules. Thanks for the opportunity to be here. Following this guy is just tough.
Yeah.
What a great idea. And I thought, well, I'm going to go back in history. We went to the meeting. Just right away. Took my opening line. But nonetheless, I'm going to press forward. I traced the start of legal writing, or one of the starts, to Federalist Papers at 83, where Alexander Hamilton, without a byline, I think he wrote anonymously at that point. But anyway, he talked about his objections to civil trials by jury, and how he thought that was a terrible idea, but in ways that spoke to his reader. Interestingly, by the way, presaging about 150 years of history, he talked a lot about women's property rights, by the way, in that. And so it was a topic I found rather intriguing in a system dominated by men. But nonetheless, what was striking about that, if you go back and look at it, is this ability really to take real life examples, to write about the law and the pending law, in his case, of what really I think was of interest to his readers, and that is, in essence, what we'd like to do. To set the picture, which is the task I have, this program called Justice and Journalism began in 1999 as a partnership with the Judicial Branch Committee of the Judicial Conference, and it was really at an initiative of the judges, and they came to our organization, which is a nonprofit, nonpartisan foundation, and we got this idea to occasionally get judges and journalists together. There was an interesting dynamic there because in the federal judiciary, there had been at that point, some very recent examples at that time of people who were warming to the contact with the press and then sort of smacked down in, dare I say, at the club for being too prominent. So we wanted to create a safe harbor for this exchange between journalists and judges to talk about issues of accountability and access and information reaching the public. And we set out early on that no one was going to, we weren't, at the end of any meeting, we were never going to come up with hard conclusions or action steps, because that seemed to be frightening to people. We were going to simply talk about what's the nature of what we do and how does it best get to our ultimate target, as you said, the public. How do they understand the law better as a result of what we all do? And then we started having these meetings on a regional basis. We started out at a national meeting, and then we began to go circuit by circuit, sometimes in the bigger circuits, splitting them up into two parts. And we convened and shoved into a room for an entire day and a half. Generally about, at the outset, 12 judges and 12 journalists. And we had to go through a sort to get to that number. And so sometimes we'd go back to a circuit a couple of years later because there were journalists or judges that we couldn't include. So we're moving along. And about 2004, 2005, an interesting phenomenon began to happen. We began to have the same number of judges interested, and it became harder and harder for us. It was our responsibility to recruit the journalists to participate, to get journalists, just find them in order to attend, who had an interest or a background or an assignment that approached full time on the course. And I think probably by about 2008, the ratio in those meetings began to go to 13 or 14, 15 judges, 8, 9 journalists. Then we added journalism educators, because we said, well, they're training the next generation, and while we can't find enough full-time practitioners, if you will, the journalism side who attend, we can talk about the next generation. And that began to decrease because we found in journalism education, typically, things hadn't changed from the medieval time when I was in school. When your entire course in the law in a journalism school consisted of how not to leave yourself open to be successfully sued for libel. That it sort of fell off in terms of any focus on the law. And you got absolutely no training on really covering courts and reporting on the law in general. And there were always exceptions, so I will acknowledge those at the outset. I'll talk about it in the main. Well, why suddenly did we have a problem even attracting people to come to these meetings? Some stats. According to reports ranging from the American Society of News Editors to Pew to others, between 2007 and 2012, 14,000 journalism jobs were eliminated. The profession fell from about 52.5 to around 38 something. I'm not sure the loss wasn't even greater. What's interesting is if you go back through those earlier numbers, well, job losses in American journalism began in the 1990s. Now, they weren't because the profession was having trouble making money. They were because the economy was slow. And there were people already beginning to look at newsrooms and slice and dice what's going on. So what happens in that? Well, you begin to look, if you're a publisher or an owner, at what are your most expensive items, where can you trim? And so you begin to look at the most experienced, the most expensive, and can you give them a buyout or just get rid of it? Well, let's look at how most news operations covered the courts. You came in, very often, I think we shared this as a young reporter, you covered the police beat. You spent a lot of time doing that, and then you maybe moved to some other things, covered government, and you gravitated toward these, really, what I think in the newsroom were the star beats, the things you really want to do. One of those was cover the courts. Now, at a lot of publications, even medium-sized publications, you were then probably, what, in your late 20s, early 30s, and you had somebody sitting there you had to push out of the way, well, wait till they retire. And so you apprenticed. You covered the Superior Court, well, they took the Circuit Court. They cut the state courts, and you covered the immunities, whatever it was. You also, by the way, almost always started out in the city court on Saturday morning, which is just a life experience, even if you have no interest in covering court. I just recommend it highly, showing up at 7 in the morning in the city court. But you worked your way up, and whether you had a legal education or not, you got one. There has always been a great antipathy in journalism, of course, to education of any kind, including journalism schools, but certainly for anybody who showed up with a degree outside of that degree, and just weren't welcome at any time. You threatened the old movie stereotype that was unfortunately very accurate stereotype. So it wasn't common at all to find people with a law degree or real background in law to be covering courts. You apprenticed, you came up the old law school fashion. You learned at the knee up. And that wasn't really a bad way in many ways because you began to see how the nuts and bolts of doing it. You know, we all know when you come out of a lot of law schools, you're not prepared to argue a case in court because the mechanics of things, what you learn early on after you're out. In journalism, you tended to get that. How do I do it along with what do I need to do to get it? Well, if you look at the job loss, and another place, the medical school analogy, I went to the CDC example. If you look at viral problems and disease, how they track it, they're worried about an outbreak, but they're worried about something called the tertiary outbreak, which is the first people get sick, and then they get sick, people around them, secondary, and then it's the people in this massive exponential explosion of disease that impacts the tertiary group. What we are seeing, this loss of jobs, is one thing. But then what that's done is take the raw number of jobs available, so more duties to be assigned to everyone. You lose your most experienced people, and suddenly you lose more than just that job slot. And then in our business, in the journalism field, in the tertiary impact, is you lose that apprenticeship, that ability to come up, you lose even the interest in the coverage of the area. because there was no voice in that room to say this is important. So we're now in that tertiary period, I fear, at most newspapers who are not fortunate to have a reporter assigned or trained or interested in covering the court. By the end of our tour through the circuits, we were having difficulty finding someone from medium-sized newspapers who covered the courts full-time. And I think it's no exaggeration today, although I've been trying to quantify this, and we may actually do a study later this year with the American Society of News Editors on who covers the courts for your news operation. We're in single digits now in a medium-sized news operation of the number of people assigned full-time to covering the federal courts. Single digits in the United States. Maybe somewhere under 5, but we need to find out. But we are having trouble finding those people who are assigned full-time coverage of the federal courts. Now, these are papers of 100,000 and up who used to have somebody that you could pretty reliably say was part of the federal courthouse, one way or another. So again, we're niching, but we're losing those things. So the savior of us all is going to be the web. You know, that's going to come along and be, no. No. Hiring in news organizations, with a rare exception, which I'm really hoping will catch on this year, hiring the web peaked in 2000 in news operation, the sort of first blush of the internet, in terms of newsroom kinds of positions. Now that's changing a little bit with Jeff Bezos buying Washington Post and Pierre Omidyar setting up, I think it's First Look Media. And there's, you know, it's interesting now, and the phrases come in that you're going to hear, which I have hope will help coverage of niche areas like the courts, which is this phrase called a long runway. I love that phrase. And what these people coming in and putting $50 more million or pledging to spend that much is what they're saying is these new operations are going to need a long runway in order to take off, and they're going to fund that long runway. So let's hope they do, and let's hope that they see the significance of reporting on the court. Too early to know there. The only place appointment in our field, if you will, has been steady is in aggregators. These are the Huffington Post and things. You know, they hire people, and they essentially in terms of their employment. AOL Patch was going to bring all kinds of local coverage and reach, you know, local is up to regional coverage back, and then of course that's now basically just evaporated. So those experiments are not good. Well, what have we lost? You're the CDC doctor or expert looking at the journalism epidemic of job loss. What have we lost? We've lost contacts, just people who know people. We've lost experience in the sense of the Anthony Lewis kind of experience. Just knowing, just being there, just soaking it up, just being around to get it. Knowledge and context. Context in the sense that one of the great quotes about Mr. Lewis, I think, was Justice Frankfurter saying he knew the cases better than the justices. You know, suddenly you see connections and links when you're analyzing an opinion, when you're looking at what judges are writing, and you're saying, you know, that has application here. And you can take a case about GPS tracking of a drug dealer in Washington and tie it to the right of petition. I mean, there's an interesting, you know, suddenly it happens. You just go, bing, and that brings a great understanding of the whole atmospherics of the law, because sometimes I think we tend to think of legal writing. One of the great things he did was take it out of the case at hand and put it into the law of the land, and say, what does it mean? What does it impact our daily life, your daily life? You lose that voice in the newsroom, I mentioned. One of the things that we discovered in our 15-year series is there just aren't people there arguing for coverage. One of the trending, and I hope soon to die, trends in our business is to rename people. You're not managing editor, you're like the content bringer honor, wizard of all, you know. I want more of a laser days. Okay, that's fine. You know, anyway, you know, there's nobody to sit there and say, wait a minute, this is an important thing for our community to know. You know, it takes cable TV, Nancy agrees. To often excite some editors. And we lose that voice that says this is important, not just because it's dramatic, flashy, or gory, or whatever, perceived by consultants to get eyeballs to screens today, but people need to know this because it's important in their lives. We lose that internal training, and again, I think still today in a lot of journalism schools, thankfully not here, there is not that connection between what really matters in terms of covering something like the courts and journalism. You just don't get it. The shift in judicial attitudes, very much something to consider today, I think, is that when we had that first program in '99, Harry Edwards, renowned, and dare we say, terrifying at times to those in front of him, proudly announced at the start of this wonderful, I was saying, this kumbaya, warm meeting between the federal judiciary and journalists and everything, and we're about 20 minutes in, and he stands and announces, I never talk to journalists. My opinion speaks for themselves. And sat back down. And I think he buttered all the way down on it. I'll never will. So he set a great tone for this guy. But I will tell you, by about 2006 or 7, we had judges coming to us saying, how better can we do this? And you began to see the experiments of public information officers repeated again. You began to see judges thinking about how to write what they used to call plain language summary at the top of an opinion, so that there was a quick read for the journalist, God forbid, who only had 10 seconds to read what was at the top. And so you begin to see the judiciary, and now, frankly, in our program, they are the driving force on how do we get things out to people, how do we cooperate. The ABA created, not as a result of our program, but sort of, hearing about it, they created that wonderful thing where journalists can now call certain law schools and get summaries of cases and talk to people. You begin to see that kind of effort from the legal profession to say, it's important to communicate. Judges also realized that they were taking it on the chin in the court of public opinion. A lot of, particularly the federal judiciary being attacked, is untouched, whatever. And they needed to reach out and defend themselves. And they can't do that directly from the bench, but they can do it through accurate reporting about the courts. One experiment that I want to just mention to close is an effort that came out of our program, the Justice and Journalism program, started by my colleague John Siegenthaler, the father of the guy in Al Jazeera. John was editor of the Tennessean, first editorial page editor of USA Today, civil rights aide to Bobby Kennedy. John endowed a program at Middle Tennessee State University. Now, New York Times, former New York Times writer, Pulitzer Prize winner Sonny Rawls, Wendell Rawls, operates essentially a news bureau that covers the courts and other federal agencies, but mostly the courts in Middle Tennessee. They're somewhere between 4 and 8 students at any given time. They're from the journalism school. There is no law school at MTSU. And they have been doing extraordinarily well in ramping up the coverage of the courts. It took a partnership with the federal judiciary there, essentially to train them. It takes professional editors to be sure that there are not problems with their copy. I know in their very first semester they did well over 120 stories. One correction, and that was a B or D in the name of one of the people mentioned in the story, and even the court documents were not clear. Otherwise, absolutely no correction on any of the stories turned out. And the ability there to come up with this innovative system is something that we hope we can help courts and news organizations, from television broadcast on, replicate around the country, because it will give, I think, rise to a new pool of people to write about the courts, but also assist the courts in a proper way, to be getting the news out, and more importantly, get news about a whole range of things that aren't going on now at both the district and the federal that simply never get a single word written about them, and we're all at a loss for that. Thank you.
On that happy note,
Yeah. Everybody
we have
gets.
time for 1 or 2 questions, if anyone has any. If not, we can move on.
For both the judge and for Gene. We go to these conferences and we, the last 5-7 years, bring our hands. Is there a scintilla of an answer? Is there a start or path towards some answer to the decline in court coverage and the increasing public stupidity about what goes on in courts?
I don't know, I'm not exactly sure what the answer is. I'm not about to suggest that judges start tweeting or blogging, okay? But I think being clear, at least so that there are sources of clear and good information, and you hope that it drives out the crap.
Yeah. I think there's an increased interest now among the legacy media and also new operations to enter into these consortiums and a willingness to do that. And you know, traditional news operations never partnered with anybody. But we're beginning to see, even at the Pulitzer level, where partnerships now, where you have experts plus in the field, plus the journalists who are more, maybe more generalists beginning to work. And I think that holds out hope for however, whether it's a group of students from a college or something with the local bar of finding new ways. Because I think when we first got hit with this loss, it was like, oh, I no longer have a courts reporter, i.e. you no longer have court coverage. And I think now there's a little more maturity as we faced up to it. Maybe the economics are coming back a little better. And and there's certainly a willingness, I think, in understanding of journalism, you have to partner more with these other kinds of operations in your newsroom, and you don't lose, the objectivity and accuracy if you're careful. So I hope there's a glimmer of progress.
Excellent. We're starting to, put out some, I hope, some wonderful future legal journalists to do this work.
Yeah.
So let me just thank our panel and invite our reporting panel down now.